Regulations for the personnel of the Roman Curia. This is the rough translation from the Italian to English using Google Translate. Title 1, General Provisions, Article 1, Section 1. This regulation contains the organizational, disciplinary, and economic norms inherent in the employment relationship of the personnel in service at the Secretariat of State, the dicasteries, the bodies and the offices that make up the Roman Curia, as well as the institutions connected with the Holy See. There, the documents referencing Pope Francis's Apostolic Constitution, Predicati Evangelium, Articles 12, 242 to 249. Section 2. Each entity has its own Ordo Servandus, approved by the Roman Pontiff. Article 2. Each institution, in accordance with the Apostolic Constitution, Predicati Evangelium, is governed by a prefect, or equivalent, hereinafter referred to as the head of the institution, assisted by one or more secretaries, and subordinately by one or more undersecretaries, without prejudice to the provisions of the Ordo Servandus of the individual institutions. Article 3. The superiors of the Roman Curia are A. The substitute for general affairs of the Secretariat of State, the Secretary for Relations with States, and the Secretary for the diplomatic personnel of the Holy See of the same Secretariat of State, the Secretaries of the dicasteries, the Regent of the Apostolic Penitentiary, the Secretary of the Supreme Tribunal of the Apostolic Signatura, the Dean of the Roman Rota, the Secretaries of the Secretariat for the Economy and the Administration of the Patrimony of the Apostolic See, and any other secretaries and those equivalent as provided for in the regulations of the individual entities. B. The Prefect of the Papal Household and the Master of Pontifical Liturgical Celebrations. Article 4. Section 1. Officials perform their duties at each institution within the limits established in the organizational chart deposited with the Secretariat of the Economy within the limits of its own budget. Section 2. Furthermore, the clerks, ushers, and auxiliaries provide their services and are distributed at corresponding functional levels. Section 3. The personnel of all 10 functional levels depend on the head of the institution for both their legal status and their activities. Article 5, Section 1. The organizational tables, their revision, and any modifications are prepared by the individual institutions in accordance with the regulation and submitted to the Secretariat for the Economy, which, after examination and evaluation by the Interdepartmental Commission for the Organizational Tables, approves them. Section 2. Every 5 years, or in the cases of particular and proven need, the organizational charts will be reviewed following the procedure in the previous paragraph. In the absence of an approved organizational chart or its revision, no staff can be hired. Section 3. The proposed modification to the organizational chart must be examined by the Interdepartmental Commission referred to in Section 1 no later than 6 months from the date of submission for the request to the Secretariat for the Economy. Title 2, Appointment Procedures, Article 6, Section 1. The following are appointed by the Pope: prefects or those equivalent to them, members and superiors of the dicasteries, bodies, and offices which make up the Roman Curia, as well as those of the institutions connected with the Holy See, the prelate auditors of the Roman Rota, the promoter of justice and the defender of the bond of the Apostolic Signatura, the promoter of justice of the dicastery for the doctrine of faith, the lay executive personnel, the undersecretaries and those equivalent to them, the prefect of the papal household, the master of pontifical liturgical celebrations, the other major officials assigned to head of the office, those equivalent to them and experts, as well as the consultors. Section 2. The personnel referred to in Section 1 are appointed for a 5-year term. Section 3. The regulations for the lay executive staff of the Holy See and the Vatican City State apply to lay executive staff. Article 7, Section 1. The office heads are appointed by the Roman Pontiff for a 5-year term upon proposal of the head of the institution. The appointment note is prepared by the Secretariat for the Economy and signed by the head of the institution. Section 2. An employee classified at the 8th functional level or higher may be appointed office head. Section 3. At the end of the 5-year term, the office head who is already employed and whose appointment is not renewed will be placed at the level prior to his appointment as office head. Section 4. At the end of the 5-year period, the newly hired office head, whose assignment is not renewed may also be reassigned to another organization. Section 5. Other officials are hired by their respective heads of institutions within the limits of the organizational chart. Hiring requires approval from the Secretariat for the Economy. Section 6. The officials will be chosen, as far as possible, from different regions of the world so that the Curia reflects the universal character of the Church. Section 7. The Secretariat for the Economy must verify the suitability of candidates. If the candidates are clerics or members of institutes of consecrated life and societies of apostolic life, the Secretariat for the Economy also requires the prior opinion of the Secretariat of State. Article 8. The subjects referred to in Article 6, Section 1, as well as those who have achieved active administrative, jurisdictional, or control and supervisory functions, according to the legislation in force, must sign upon taking up the office or assignment the declaration according to the current regulations issued by the higher authority. There, the document is referencing the rules in force on the, or has a footnote that says the rules in force on the date of the publication of this regulation are contained in the provision of Pope Francis' apostolic letter in the form of a motu proprio containing provisions on transparency in the management of public finances, April 22nd, 2021, see Annex 1. End of footnote. Title 3, Staff Classification, Chapter 1, Common Rules, Article 9, Section 1. The staff is selected from among those who stand out for their virtue, prudence, knowledge, and appropriate experience. Section 2. They must possess the following requirements. A. Profess and live the Catholic faith. B. Have no criminal record or pending criminal convictions. C. Be at least 18 years of age. D. Be suitable and competent for the work to be performed as established in the following Section 5. Section 3. For clerics and members of institutes of the consecrated life and societies of apostolic life, the nihil obstat of their respective competent ordinary or superior is also required, and if residing in Rome, also of the Vicariate of Rome. Section 4. All personnel must obtain a certificate of physical and psychological fitness for the task to be performed, certified by the Directorate of Health and Hygiene of the Government of the Vatican City State. Section 5. The organizational chart of each institution establishes for each role provided for therein, A. The corresponding educational qualification, B. The years of experience gained in similar roles with other employers or independently, C. Knowledge of one or more languages in addition to the mother tongue and Italian, D. The skills and requirements necessary to fulfill the assigned role. Section 6. Regarding the academic qualification, the organizational chart must generally provide the following. A. To be admitted to levels 10, 9, and 8, a high school diploma or master's degree. B. To be admitted to level 7, a baccalaureate or 3-year degree. C. To be admitted to level 6, a secondary school diploma or similar qualification. D. To be admitted to the remaining levels, you must have fulfilled your compulsory education requirements according to the legislation of your country. Article 10. Section 1. The following documents must be produced in order to be hired. A. Identity document. B. Certificate of residence. C. Residence permit, if applicable. D. Certificate proving educational qualifications. Section 2. For lay personnel, the following are also required. A. Baptismal and confirmation certificates. B. For married couples, canonical marriage certificate. C. Certificate of religious and moral commitment issued by their parish priests. D. Criminal record certificate and certificate of pending charges dated no more than 3 months earlier. E. Additional documentation necessary to demonstrate other requirements for the specific role to be filled. F. Declaration of acceptance of the exclusive jurisdiction of the Court of the Vatican City State regarding any dispute relating to the employment and or collaboration relationship to be established. G. Unlimited leave for those subject to military service. Article 11, Section 1. The employment relationship is governed exclusively by the rules of the Holy See. Any disputes concerning the aforementioned relationship are subject to the exclusive jurisdiction of the Court of the Vatican City State. Section 2. All persons upon appointment or hiring must be familiar with these regulations and with the Ordo Servandus of their own institution, which they are required to observe, and it cannot be claimed that they are unaware of them. Section 3. All upon appointment appointment or hiring must make a profession of faith and take an oath of fidelity and observance of official secrecy before the head of the institution or another superior using the formulas reported in the appendix. Chapter 2, Hiring of Secular Clerical Officials and Members of Institutes of Consecrated Life and Societies of Apostolic Life, Article 12, Section 1. Officials belonging to the secular clergy and members of institutes of consecrated life and societies of apostolic life are, as a rule, hired under a 5-year contract, which may be extended for another 5-year period by agreement between the head of the requesting institution and the respective ordinaries or superiors of the institute or society to which they belong, subject to prior authorization from the Secretariat for the Economy. The agreement will also define the terms relating to the guarantee of the Social Security system in accordance with the provisions of the norms of the Holy See. The provisions of this article relating to secular clerics and members of institutes of consecrated life and societies of apostolic life are not applicable to married clergy. Section 2. For the period of service, Social Security and welfare coverage must be provided in accordance with the regulations applicable to all Holy See personnel. An assurance policy must be taken out for employees who at the date of termination of service have not accrued their right to immediate or deferred pension benefits. Section 3. Before finalizing the agreement referred to in Section 1, the organization must in any case consult the Secretariat for the Economy. A copy of the agreement must be given to the employee upon hiring. Section 4. In the event of loss of the clerical state or definitive separation from the Institute of Consecrated Life or the Society of Apostolic Life, the employment relationship with the Holy See is considered to have ceased. Section 5. The probationary period is governed by the provisions of Article 15, Sections 1 through 4 of these regulations. Chapter 3. Recruitment of lay personnel, Article 13, Section 1. Candidates are hired on a probationary basis for a period of at least 1 year, which cannot be extended beyond 2 years. Any period of continuous employment in the same role immediately preceding hiring will count toward the probationary period. Section 2. The probationary appointment is communicated to the interested party in writing. Section 3. The functional level is established by the relevant institution in accordance with the organizational chart, subject to verification by the Secretariat for the Economy in relation to the duties for which the candidate is hired. Section 4. During at the end of the probationary period, the head of the institution shall dismiss, with an unquestionable provision communicated in writing, the candidate who proves unsuitable. Article 14, Section 1. The hiring of blood relatives up to the 4th degree and of 1st and 2nd degree relatives by marriage, according to canonical calculation, into the same institution is prohibited. Section 2. This criterion also applies to separate entities if the hiring of blood and in-law relatives in the opinion of the Secretary of the Economy is deemed to conflict with the duties to be performed. Article 15, Section 1. The probationary period is computed for the purpose of seniority and any retirement benefits. Section 2. The salary of a probationary employee is subject to deductions for health care, pension, and severance pay. Section 3. The probationary period is suspended in the event of the employee's absence due to illness, injury, or family reasons which, in the opinion of the head of the relevant institution, are deemed serious, having informed the Secretariat for the Economy. Section 4. In the event of injury or illness resulting from service-related circumstances during the probationary period, the provisions set forth in Articles 57 to 58 shall apply. Section 5. Probationary period is suspended in the event of maternity leave of the employee. Article 16. At the end of the probationary period, the head of the institution, after having sent the candidate's evaluation to the Secretariat for the Economy, proceeds with the nomination of the candidate with a specific note. Chapter 4. Other types of contracts. Article 17, Section 1. For the hiring of personnel for a limited period of time or for the assignment of tasks and other professional services, the following type of contracts may be used. A. Fixed-term employment. B. On-call contract. C. Assignment of temporary professional assignment. Section 2. It is also possible to carry out activities through A. Internship. B. Volunteering. Article 18, Section 1. Staff may be hired on a fixed-term basis. A. To cover prolonged absences of personnel entitled to retain their jobs, for whom it's not possible to provide staff currently employed by the institution. B. In the event that the institution is entrusted with additional activities or extraordinary activities limited in time. C. When the ordo servandus or the institution's organizational chart so provides in relation to the particular configuration of the institution's activity, which may require additional personnel only during certain periods of the year. Section 2. Fixed-term employment may be full-time or part-time in accordance with the provisions of the following Article 47. Section 3. Hiring subject to the approval from the Secretariat for the Economy must be for the time necessary to meet the needs that led to it, upon motivated request from the institution, in any case for a period not exceeding 5 years, in the event of renewals and extensions, provided that the conditions set forth in Section 1, A, B, and C above are met, and always within the overall limit of 5 years. Approval from the Secretariat for the Economy is required again. Section 4. The economic and regulatory treatment provided for by this regulation for permanent staff shall apply to staff hired on a fixed-term basis, except as follows. A. In the event of absence due to illness or injury, Articles 57 and 58 of these regulations shall apply, where compatible. The period of job retention is equal to the duration of the contract and may not, in any case, exceed the maximum terms established in Articles 57 and 58. In the event of injury or illness resulting from the service-related circumstances, the provisions of Article 58 shall apply. B. In the event of absence from work due to maternity leave, pursuant to Article 60, Sections 8 through 9, where the employment relationship is terminated due to the expiration of the term, the interested party shall be paid, together with the severance pay, an indemnity equal to 80% of the monthly salary referred to in Article 60, Section 5, multiplied by the number of remaining months of maternity leave provided for in the aforementioned paragraphs. Section 5. The remuneration of personnel hired on a fixed-term basis is established in the amount corresponding to the functional level required by the tasks assigned and is subject to withholdings for health care, pension, and severance pay. Section 6. Staff employed on a fixed-term basis are entitled, insofar as compatible with the type of contract, to all social benefits provided to staff employed on a permanent basis. Section 7. Staff are hired under a contract stipulated by the head of the institution on which they depend for their legal status, subject to approval from the Secretariat for the Economy. Section 8. The contracts referred to in Section 1 do not entitle the employee to permanent employment, and the employment relationship ends upon expiry of the term. Article 19, Section 1. For the performance of discontinuous or intermittent services for technical, organizational, or replacement needs, or when the need for non-predictable services arises in particular periods, the head of the institution may stipulate so-called on-call contracts, provided that they are within the limits of his or her own budget and for a limited period of time. Section 2. The on-call contract is stipulated by the head of the institution on which the worker depends, in accordance with the regulations issued by the Secretariat for the Economy. Section 3. The contracts referred to in Section 1 do not entitle the employee to permanent employment, and the employment relationship ends upon expiry of the term. Article 20, Section 1. The head of the institution, for proven needs that cannot be met by the staff employed or provided for in the organizational chart, may assign within the limits of his budget tasks or request other intellectual work services necessary for the institution itself. Section 2. The assignment of the task subject to approval from the Secretariat for the Economy is entrusted by the interested bodies through a specific deed. Section 3. The assignment is normally for a maximum of 1 year. Any subsequent renewals require the approval of the Secretariat for the Economy. Section 4. The collaborator must have professional liability insurance and pension coverage unless otherwise specified by the Secretariat for the Economy. Section 5. The assignments of duties referred to in the previous paragraphs do not entitle the candidate to permanent employment and cease upon expiry of the term. Section 6. The assignments are compensated on a lump sum in quotes basis according to the agreement between the parties and do not entail obligations for Social Security or welfare benefits on the part of the Holy See. Article 21, Section 1. Those with the required qualifications, subject to approval from the Secretariat for the Economy, may undertake an internship at an institution, lasting no more than 1 year, to supplement their training. The internship may not be used in any way to fill any staffing shortages. Section 2. The internship, to be formalized with a written document that regulates its implementation, is aimed at achieving training project for the intern under the supervision of a tutor and does not in any way constitute an employment relationship, nor does it replace the probationary period required for hiring. Section 3. At the end of the internship period and upon request of the interested party, the institution issues a certificate. Section 4. The internship does not entail any remuneration, Social Security, or assistance costs for the Holy See, except for accident and third-party liability insurance coverage and any reimbursement of previously agreed and duly documented expenses. Article 22, Section 1. The voluntary work of individuals who wish to offer free and unpaid services to organizations for a certain period of time is left to the prudent judgment of the head of the organization, subject to approval from the Secretariat for the Economy. Section 2. The person who voluntarily provides his or her services must have the moral requirements required of employed personnel. Section 3. The period of time for which a person undertakes to provide his or her collaboration is determined in agreement with the head of the institution. Section 4. The head of the institution may terminate the aforementioned service at any time, notifying the Secretariat for the Economy and the interested party. The interested party may do the same, informing the head of the institution in due time. Section 5. These services do not entail any remuneration, Social Security, or pitching costs for the Holy See, except for any reimbursement of previously agreed and duly documented expenses. Section 6. The entities benefiting from the activities referred to in the previous article, sections 1 through 5, are required to ensure through the Secretariat for the Economy the following for the people who carry out voluntary work. A. Against accidents and illnesses connected to the performance of said activities. B. For civil liability towards third parties. Title 4. Staff Mobility, Article 23. Vacancies in the organizational chart may be filled subject to approval from the Secretariat for the Economy by moving a person from the same institution to that level, by transferring from another institution, or by hiring a new person depending on the needs of the office, taking into account educational qualifications and proven specific suitability for the position in question, ignoring any other criteria, including merely seniority. Article 24, Section 1. For service and organizational needs, staff may be transferred by order of the head of the institution temporarily or permanently to carry out their duties in another office of the same institution, maintaining the same salary level. Section 2. The transfer referred to in Section 1 shall be notified in writing to the interested party and communicated to the Secretariat for the Economy as appropriate. Article 25, Section 1. For service and organizational needs, staff may be transferred temporarily or permanently to carry out their duties at another institution of the Roman Curia, maintaining the same salary level in accordance with the organizational chart. Section 2. To proceed with the transfer referred to in Section 1, prior agreement between the heads of the interested bodies and the authorization of the Secretariat for the Economy is required. Section 3. The provision is notified in writing to the Secretariat for the Economy by the head of this institution, receiving the employee, and to interested party by the head of the institution from which the employee was transferred. Title 5. Staff Duties, Article 26, Section 1. The head of the organization is responsible for governing and directing his organization, overseeing all of its activities, and representing it in all respects. Section 2. The head of the institution is responsible for managing his or her own personnel according to internal organizational models in compliance with this regulation. Article 27. The secretary or equivalent, with the assistance of the undersecretary or similar figure, assists the head of the institution in managing staff and handling institution matters. He or she participates in all ordinary and plenary sessions with voting rights. Therefore, following the directives of the head of the institution and in agreement with him, in compliance with the Ordo Servandus specific to each institution, A. Coordinates and plans the initiatives and various services, assigns the sector of activity to each, follows with particular attention the most important matters, takes care of the drafting of documents and the prompt handling of office practices, supervises the discipline and the observance of the present regulation and of the Ordo Servandus of the entity. B. Entrusts the consultors with the study of the practices for which their vote is deemed necessary, convenes the consulta when necessary, and provides over it. That's referencing General Regulations of the Roman Curia, Article 26. C. Prepares the reception of the bishops of their ad limina apostolorum visits. D. Replaces the head of the entity when he is absent or impeded. E. Signs together with the head of the entity the acts of the entity according to the norms of his own ordo servandus. F. Transmits to the Secretary of State the documents that must be published in the Acta Apostolicae Sedis. G. Reports regularly to the head of the institution on the progress of procedures and, in particular, on matters that need to be notified or referred to other institutions or that fall outside the scope of ordinary procedures or require special measures. H. Oversees the preparation of the budget estimates and final accounts to be submitted to the Secretariat for the Economy and carefully monitors their implementation. Article 28. The Undersecretary and those who perform equivalent duties, according to the rules of their own ordo servandus, A. Assist the Secretary or equivalent in managing the staff and in handling the affairs of the institution, ensuring its functioning. B. In the event of the absence or impediment of the Secretary or equivalent, they replace him according to the institution's own ordo servandus. C. They may be authorized to sign explicitly specified documents. D. Act as actuaries in ordinary and plenary sessions. E. Carry out the specific activities the Secretary or equivalent assigns to them. Article 29. The functions of the staff are determined by the ordo servandus of each institution in execution of the general mandate of the Roman Curia. Title 6. Functional levels. Article 30, Section 1. The officials and personnel referred to in Article 4, Sections 1 through 2, are distributed across 10 functional levels, each of which corresponds to the remuneration established by the regulations issued by the Secretariat for the Economy. Section 2. Each functional level includes various tasks listed in the job description list of the Roman Curia reported in the appendix. Section 3. Office heads receive, in addition to the remuneration established for their functional level, an allowance established by the Secretariat for the Economy. Section 4. The number of positions provided for each functional level is indicated in the organizational tables approved for the individual institutions. Section 5. Within the employee's level of membership, new duties may also be assigned to the employee if, in the judgment of the superiors referred to in Article 2, they deem necessary due to changing organizational and work needs. Section 6. Staff must be available to collaborate temporarily according to the provisions of their superiors, even in tasks not related to their own functions, and to replace absent colleagues. Article 31, Section 1. An employee belonging to a certain level may temporarily assigned the functions of a higher level in the following cases: A. Due to a vacancy in an organizational position. B. To replace absent employees with the right to retain their position. C. For other objective service needs. Section 2. The temporary assignment of higher functions is arranged with a formal act by the head of the institution notified to the Secretariat for the Economy. Section 3. The transfer, A. It can never exceed, for the protection of the employee, a duration of 6 months. B. It never gives the right to promotion to a higher level. C. It never gives the right to an increase in any form in salary. Section 4. Assignment to lower duties may be ordered by the head of the institution only for objective service needs and may not last longer than one continuous year or 1 year in a 3-year period, maintaining in any case the same treatment corresponding to the officer's level of membership. Article 32, Section 1. Except as provided in the following Section 3, the head of the institution, after consulting the Secretary, assessing the provisions of Article 9, Section 4, the candidate's professional competence and aptitude for carrying out the new functions, and with the approval of the Secretariat for the Economy, may proceed with promotion to a higher level. Section 2. Before being assigned to a higher level, the employee must remain at the immediately lower level for a period of no less than 1 year. Section 3. A promotion to a higher level may be granted when it involves an actual change in duties, duly documented within the limits of the budget and the organizational chart, without prejudice to the professional skills acquired and demonstrated in the performance of the duties, periodic performance evaluations, and participation in professional development and training activities relevant to the role. Article 33, Section 1. The head of the institution, subject to approval from the Secretariat for the Economy, may proceed with the assignment of horizontal merit classes in accordance with current legislation. Section 2. The assignment of horizontal merit classes does not entail any change in either the job description or the level as described in the job description attached to this regulation. Section 3. An employee who has been subject to a disciplinary sanction in the last 5 years of service cannot be a candidate for the assignment of merit classes. Article 34. The head of the institution will send an annual evaluation of the service provided by staff to the Secretariat for the Economy based on criteria of dedication, professionalism, performance, and fairness in carrying out the service as required by specific legislation. Title 7. Duties of the Staff. Article 35. Those who work in the Roman Curia, as they participate in the universal mission of the Roman Pontiff, provide an ecclesial service marked by a pastoral and missionary character. They form a working community that must be distinguished by the spirit that animates it. Article 36. Staff have a duty to carry out their work with diligence, accuracy, a sense of responsibility, and a spirit of full cooperation. Article 37. Staff are required to maintain exemplary religious and moral conduct, including in their private and family lives, in accordance with the doctrine of the Church. Article 38. Staff are required to communicate any changes in the composition of their family to the head of the institution, who will inform the Secretariat for the Economy within 30 days of their occurrence, and to keep their availability data updated, promptly informing them of any changes in residence and any domicile. Article 39, Section 1. Secular clerics and the members of the Institutes of Consecrated Life and Societies of Apostolic Life are required to wear ecclesiastical dress or the habit of their own institute or society. Section 2. Lay personnel are required to wear decent dress. Article 40. Section 1. Everyone is obliged to strictly observe professional secrecy. Therefore, they may not disclose to anyone who is not entitled to do so information relating to documents or information they have learned in the course of their work. Section 2. The current legislation on pontifical secrecy will be observed with particular care. Article 41, Section 1. Without prior authorization from the head of the institution or from anyone delegated by him, no official or worker of the institution may release, through the media, statements and interviews, or make public information regarding the people, activities, and orientations of the institutions of the Roman Curia. Section 2. Official communications and statements to the press must be released only through the dicastery for communication. Article 42. Those who work in the Roman Curia should actively engage within the limits of their office commitments and other works of the apostolate according to their specific vocation. Article 43. Staff have a duty to keep themselves up to date on doctrinal and technical matters regarding their specific work, encouraged and assigned by their organization. Article 44. It is prohibited: A. Leave one's workplace without permission from the competent superior. B. Receive strangers into one's office. C. Violate regulations regarding environmental protection. D. Violate regulations regarding workplace safety. E. Engage in activities or participate in events that are inconsistent with the duties of an employee of the Holy See. F. Join institutions or associations whose purposes are incompatible with the doctrine and discipline of the Church, otherwise participate in their activities. G. Assume positions at other entities of the Holy See without the express authorization of the head of the entity. H. Engage during working hours in occupations unrelated to one's office or service. I. Practice professions, assume or retain employment of positions, even private ones, even of an ecclesiastical nature, that, in the opinion of the head of the entity, are incompatible with or detrimental to one's official duties. In any case, it is the employee's duty to notify the head of the entity in advance of any intention to assume additional employment or positions. J. Improperly using office stamps and letterhead, as well as one's institutional email addresses. K. Using office premises, computer materials and software, tools, and equipment owned by the organization for private purposes or purposes unrelated to the organization or office's purposes, even following an inspection by the organization of its computer devices, may be available to the employee. L. Disclosing original documents, photocopies, electronic copies, or other archival and work materials relating to the office, and private notes or memos regarding matters handled in the organization. M. Accepting or soliciting for oneself or for persons other than the organization in which one serves by reason of or taking advantage of one's office, gifts, presents, or other benefits of a value greater than that established by the rules referred to in Article 8 of this regulation. And receiving commissions or a compensation for the performance of official duties. O. Directly or indirectly pursuing private interests in carrying out one's office activities in accordance with applicable law. Article 45, Section 1. The organization has the right to seek recourse against its personnel, regardless of their contract, for any damage caused to the organization through fraud or gross negligence. Section 2. In the event of a dispute, the Tribunal of the Vatican City State has exclusive jurisdiction. Title 8. Working Hours, Holidays, and Vacations. Article 46, Section 1. The ordinary working hours are 36 hours per week. Section 2. Organization heads may allow individuals half an hour's flexibility in their arrival and departure times. Section 3. Any temporary reduction in individual working hours must be agreed upon between the parties and communicated to the Secretariat for the Economy for the corresponding reduction in salary and a corresponding proportional reduction in contributions. Such reduction must not exceed 6 hours per week and may not last longer than 6 months, except for secular clerics and members of the Institutes of Consecrated Life and Societies of Apostolic Life. Section 4. For certain activities, at the request of the head of the institution, the Secretariat for the Economy may establish ordinary working hours different from those indicated in Section 1. Article 47, Section 1. The Secretariat for the Economy may authorize institutions to establish part-time employment relationships where service needs do not justify full-time employment. Section 2. The legislation in force for full-time staff applies to the hiring of part-time staff. Section 3. A part-time employee fills a fraction of a staff position corresponding to the duration of their work, which cannot be less than 50% of the full-time position. In any case, the sum of the fractions of part-time positions cannot exceed the total number of full-time positions. Section 4. The part-time employment relationship must be evidenced by a written document and must contain an indication of the duration of the work performance referred to in the following Section 5. Section 5. Part-time work can be done, A, with the provision of service reduced across all working days, horizontal part-time, in other words, B, with the provision of service spread across some days of the week, that would be vertical part-time, to such an extent as to respect the average weekly working hours envisioned for part-time. Section 6. Part-time employees are excluded from performing overtime work. Section 7. The remuneration due to part-time employees is established with reference to that of full-time staff of the same functional level according to proportionality criteria for all salary items referring to the hours of service performed and is subject to withholdings relating to the applicable health care, pension, and severance pay. Section 8. Staff with horizontal part-time employment relationship are entitled to the same number of hours of vacation as full-time employees. For staff with a vertical part-time employment relationship, the number of vacation hours is reduced proportionally. Section 9. For part-time employees, taking into account the reduced duration of the service of the specific nature of its performance, the provisions of other regulatory institutions established for full-time employment shall apply where compatible. Article 48, Section 1. Working hours must be strictly observed, and compliance with them is ensured through suitable checks and according to the methods established by the institution. Section 2. Temporary absences during working hours, whether for work-related or personal reasons, must always be previously authorized by the organization's superior. Section 3. Any employee who repeatedly fails to observe working hours without justifiable reason will be subject to disciplinary action in addition to the deduction from wages proportional to the time taken away from work. Section 4. The employee must ensure that service begins at the predetermined time. In the event of illness or other unforeseen impediment, the employee must comply with the provisions of Article 57 and what follows. Article 49, Section 1. Employees are entitled to 1 day of rest per week, which falls on Sunday. Section 2. For employees who, due to unavoidable service needs, must work on Sundays, the weekly rest day is set on the weekday to be agreed upon with the head of the organization. Article 50. The use of overtime work on holidays and at night is regulated by the applicable legal provisions. Article 51, Section 1. For service reasons, employees may be sent on missions outside their usual place of work. Section 2. Travel and accommodation expenses for personnel sent on missions shall be borne by the institution to which they belong, according to the procedures established by the Secretariat for the Economy. Section 3. If the trip involves a time zone change of more than 3 hours, staff may take a day off within 24 hours immediately following their return. Section 4. Personnel sent on business trips are paid compensation as set forth in Article 86. Article 52. In addition to Sundays and other holy days of obligation, there will also be holidays: A, the anniversary of the election of the Roman Pontiff; B, the name of day of the Roman Pontiff; C, the anniversary of the establishment of the Vatican City-State; D, the liturgical memorial of St. Joseph the Worker; E, the last 3 days of Holy Week; F, Easter Monday and Tuesday; G, the eve and the day after the Assumption of the Blessed Virgin Mary; H, the commemoration of all the faithful departed; I, the eve and the 2 days after Christmas; J, the last day of the year. Article 53, Section 1. Employees are entitled to annual leave, amounting to a total of 158 hours, to be used exclusively on full working days. In the event of working hours are of less than 36 hours per week, this principle of proportionality will apply. Section 2. Holidays are calculated on a calendar year basis. For fractions of a year or month, the number of hours of holiday to which one is entitled is proportional to the time worked. Section 3. Vacation is an inalienable right and cannot be cashed. It must be taken with prior authorization during the calendar year for at least a period of 74 hours in total, consistent with service needs. Section 4. An employee who requests it must in any case be guaranteed at least half of the hours of vacation due in the period from June 1st to September 30th. Section 5. Annual leave cannot be accumulated with leave not taken in the previous calendar year. Upon termination of service, if the leave due to that date has not been taken due to document service needs, it will be paid in lieu. Section 6. For service needs, and with the prior authorization of the head of the institution, holidays up to a maximum of 1/3 may be taken by March 31st of the following year. Section 7. If due to the unforeseeable service needs, the employee is unable to enjoy vacation during the period established pursuant to Section 3, the right to reimbursement of any expenses incurred arises, provided they are adequately documented. Section 8. Holidays are interrupted by illness or injury. They have resulted in hospitalization and were provided for by the, quote, consolidated law on family benefits, in quotes. Section 9. The organization develops guidelines for identifying vacation periods according to service needs. Title 9. Suspension of work activity. Article 54. They suspend work actively: A, permits; B, sick leave; C, leave of absence. Chapter 1. Permits. Article 55. Section 1. In compliance with canonical prescriptions, secular clerics, members of institutes of consecrated life, and societies of apostolic life may benefit each year from 6 consecutive solar calendar days of paid leave for the normal course of spiritual exercises. Section 2. Lay employees belonging to associations of pontifical right and diocesan right may, upon request, benefit each year from up to 6 consecutive calendar days of paid leave for the normal course of spiritual exercises established by the approved statute. Section 3. The period of absence due to leave for spiritual exercises must always be agreed upon and authorized by the head of the organization. Article 56, Section 1. Permits are granted for specific reasons and by the head of the institution, who communicates them to the Secretariat for the Economy. Section 2. Paid leave is automatically granted in addition to the cases recognized by the Consolidated Law on Family Provisions on the following occasions: A, for the death of blood relatives or in-laws in the first or second degree according to the canonical calculation, a period of 5 calendar days in addition to the duration of any travel. B, to take exams related to work performed for the Apostolic See, the day strictly necessary. C, for lay people on the occasion of marriage, 15 calendar days. Section 3. Staff are granted upon request consistent with service needs and without the need for documentation and or justification 18 hours of paid leave per year for personal and or family reasons according to the following procedures. A, leave may be requested for a period of no less than 1 hour, including the entire duration of the daily working hours, always within the limits set forth in this paragraph. B, to take advantage of leave, the employee must submit a written request and with reasonable notice to the competent superior. In cases of extreme urgency, an oral request is sufficient. C, the competent superior must expressly authorize the request, which may be refused or deferred only for serious service reasons. D. Leave does not affect vacation entitlement and is considered for the purposes of calculating seniority. E. Leave cannot be taken on the same day in conjunction with other types of leave as provided for in the regulations. F. Unused leave hours cannot be cashed and are reset to 0 at the end of each calendar year. Section 4. Paid leave may be granted on the following occasions. A. In the event of a serious life-threatening illness of a spouse, first and second degree blood relatives, or in-laws according to canonical calculations, a period of 5 calendar days, extendable at the discretion of the head of the organization. B. On the day of the blood donation. C. In urgent and unavoidable situations proven by appropriate medical certification only and duly authorized by the head of the organization for medical visits, specialist tests, and treatments, is the employee's responsibility to provide their organization with evidence of having actually undergone the visits, tests, and treatments covered by the leave. Section 5. Paid leave may also be granted when it is necessary to appear before judicial authorities and in both ecclesiastical and civil courts. Leave is granted for the time strictly necessary. Section 6. For other reasons, unpaid leave may be granted consistent with service requirements, provided that the leave periods do not exceed a total of 6 working days during the calendar year. Chapter 2. Absence due to illness. Article 57, Section 1. In the event of illness or injury, the employee is required to inform his or her direct superior on the first day of absence within the first hour of his or her working hours, indicating where he or she can be found. Section 2. Within the day following the onset of the illness, the employee is required to justify the aforementioned absence with the relevant medical certificate indicating the presumed duration of the illness. Section 3. The Secretariat for the Economy may, at any time during working hours, arrange for medical checkups by medical personnel from the Directorate of Health and Hygiene of the Governorate of the Vatican City State. Furthermore, the employee who is ill must be available during working hours at his or her home or at a different location designated by him or her. It must also report any absences authorized by the attending physician. Section 4. If the employee is not found at the location indicated in Section 3 or has not produced the documentation referred to in Section 2, or the reasons given to justify the absence are otherwise proven to be non-existent or insufficient, the absence is considered arbitrary and the employee, in addition to losing his or her salary, is liable to the disciplinary action. Section 5. In the event of illness resulting from an accident not at work, caused by any third-party liability, the employee is required to notify the relevant institution in any case. Article 58. Section 1. After a total of 20 working days of absence due to illness in a calendar year, the employee shall undergo the medical fitness examination referred to in Article 75, Section 2. Section 2. An employee absent due to illness is entitled to retain their position for a period of 18 months. For the purposes of calculating the aforementioned period, all sick leave periods in the 3 years preceding the last ongoing illness are added together. Days of sick leave or injury due to work-related causes are not counted towards the accrual of the aforementioned period. Section 3. Upon exceeding the aforementioned period of absence, the employee may be dismissed from service pursuant to Article 75. Section 4. The application of the, quote, rules for the protection of employees suffering from particular serious pathologies or in particular psychophysical conditions, in quotes, remains unchanged. Section 5. During sick leave, you're entitled to full pay, excluding any compensation related to attendance at work. Section 6. Time spent on sick leave is counted for all purposes relating to seniority. Section 7. In the cases of injury or illness resulting from the work-related events, the procedures is in accordance with the current, quote, rules for the regulation of benefits due to personnel who have suffered physical or mental injury due to an accident or contracted illness resulting from work-related events, in quotes. Chapter 3. Expectation. Article 59. The head of the institution may order leave of absence for maternity, personal, or family reasons. This decision must be promptly communicated to the Secretariat for the Economy. Article 60, Section 1. Maternity leave is arranged on the basis of a specific medical certificate confirmed by the Directorate of Health and Hygiene for the Government of the Vatican City State. Section 2. The expectation begins 3 months before the expected date of birth and continues for 3 months after the birth. Section 3. Upon request of the interested party and following the opinion of the specialist doctor and the competent doctor of the Directorate of the Health and Hygiene of the Government of the Vatican City State, maternity leave may begin up to 1 month before the expected date of birth and continue for 5 months after the birth. Section 4. After giving birth, the interested party must send the birth certificate to the relevant office for the calculation of the subsequent period of leave. Section 5. During the period of maternity leave, full remuneration is paid, excluding compensation relating to attendance at work. Section 6. Time spent on maternity leave is counted for all purposes related to seniority. Section 7. Throughout the period of direct or mixed breastfeeding, which must be documented with a medical certificate, a reduction in working hours of 2 hours per day is granted until the child reaches 1 year of age. The reduced working hours must, however, be structured on a continuous basis. Section 8. Leave of absence beyond the period established in the previous paragraphs may be extended for a further maximum period of 6 months, which may be taken in installments no later than the child's 3rd birthday, with a monthly salary reduced by 50%. This period is computed with the purposes of seniority and any retirement benefits, subject to payment of the relevant withholdings calculated on the entire salary due to the employee during such periods. Section 9. The provisions of Title II, quote, benefits for maternity protection, in quotes, and Title III, quote, benefits for employees with disabled family members, in quotes, of the, quote, consolidated law on family benefits, in quotes, integrate the provisions of the previous paragraphs. Article 61. Section 1. Leave of absence for personal or family reasons may be granted upon written request of the employee not on probation for duly verified serious reasons. Leave of absence for family reasons may be granted in accordance with the provisions of the, quote, consolidated law on family benefits, in quotes. Section 2. The head of the institution shall decide within 30 days of the submission of the application and has the right, for reasons to be stated in the provision, to reject it, to delay its acceptance, and to reduce the duration of the requested leave of absence. Section 3. Leave of absence for personal or family reasons may not last more than 6 months, continuous or uninterrupted, during the first decade of service, no more than 1 year, continuous or uninterrupted during the subsequent period. Furthermore, it may be suspended or revoked for reasons of service with adequate notice. Section 4. During leave of absence for personal or family reasons, remuneration is not paid, and seniority is suspended for all purposes. Time spent on leave is not counted towards vacation entitlement. Health care may be continued at the interested party's request and at their sole expense. Title 10. Disciplinary Rules, Article 62. Section 1. Behavior contrary to these regulations are punishable by disciplinary sanctions to be applied in accordance with the following articles. Section 2. Disciplinary sanctions are A. Oral warning, written warning, and pecuniary fine. B. Suspension from office. C. Dismissal from office. D. Automatic removal from office. Section 3. The Disciplinary Commission of the Roman Curia will act in accordance with its own regulations to determine the disciplinary sanctions referred to in Section 2, B, and C. Chapter 1. Oral warning, written warning, and pecuniary fine. Article 63, Section 1. The oral warning, the written warning, and the pecuniary fine, not exceeding 2 working days' wages, are imposed according to the seriousness of the infringement and any repeat offenses, A, for indiscipline, B, for insufficient performance or negligence in service, C, for inappropriate, incorrect, or rude behavior towards colleagues and the public, D, for unjustified failure to observe working hours and failure to comply with procedures for determining one's own working hours, E, for violations of the prohibitions referred to in Article 44 from A to C, F, for unjustified absence from service due to illness pursuant to Article 57, Section 4. Section 2. The oral warning must be recorded in the personnel file held by the institution. The written warning and the financial fine must be kept in the personnel file held by the institution and by the Secretariat for the Economy. Section 3. An employee who commits one of the violations set forth in the preceding paragraphs and has already been punished for an infringement of the same type may be subject to a sanction more serious than that provided for the infringement itself. Provided for the infringement itself. Chapter 2. Suspension from office. Article 64. Section 1. Suspension entails temporary removal from office with loss of pay, net of Social Security, and welfare deductions, excluding family allowance. Section 2. The suspension applies by order of the head of the institution for up to a maximum of 30 days. A. For a repeat of the offense is punishable by a written warning and a fine after these have been applied twice within a period of 1 year. B. For infringement of the prohibition set forth in Article 44 from D to M. C. For acts of insubordination. Section 3. For the following cases, a suspension period of more than 30 days and up to a maximum of 3 months applies, subject to a decision by the Disciplinary Commission on the legitimacy and appropriateness of the sanction imposed by the head of the institution. A. For serious harm caused to the institution. B. For violation of official secrecy. C. For any other irregularity in private regulations that is detrimental to the dignity of the institution. D. For violations referred to in Section 2B of a particularly serious nature in the opinion of the head of the institution. Chapter 3. Dismissal from office. Article 65, Section 1. Dismissal from office applies: A. For serious acts of indiscipline and insubordination. B. For serious violation of official secrecy. C. For persistent underperformance and negligence in the performance of work duties. D. For repeated negative evaluations by the head of the institution. E. For serious failures to fulfill the duties of one's position or office. F. For serious abuse of authority. G. For illicit use of misappropriation of funds administered or held in trust or other assets of the Holy See. H. For violation of the pontifical secrecy pursuant to Article 40. I. For evidence resulting from judicial or disciplinary proceedings that suggests the employee's continued service is incompatible with the dignity of the employment in the Holy See. J. For failure to assume service except in the cases of proven impediment after periods of interruption of activity as provided for by applicable legislation. Section 2. The Commission referred to in Article 62. Section 3. Will examine these cases. In Article 62, Section 3 will examine these cases. The accused will be given the opportunity to defend himself. Section 3. Cases of repeated offenses already punishable by suspension from office pursuant to Article 64 may be submitted to the aforementioned commission for examination. Article 66. The dismissed employee cannot be rehired by another entity dependent on the Holy See, and written notification of the dismissal must be given to the government of the Vatican City State. Chapter 4. Removal by right. Article 67, Section 1. A person shall be automatically dismissed from office if he or she has been convicted of a criminal offense, including a criminal offense committed prior to taking up office, and is issued by the competent authority of the Vatican City State or another jurisdiction which deems the employee's continued service incompatible with the dignity of his or her position in the Holy See. In these cases, no assessment of the facts is required. Section 2. A person who has been dismissed from office may not be reinstated by another entity dependent on the Holy See. Written information regarding the disciplinary procedure must be provided to the government of the Vatican City State. Chapter 5. Procedure for the application of disciplinary sanctions. Article 68, Section 1. If the superior, if he becomes aware of the facts that may lead to disciplinary sanctions, must carry out the necessary investigations and forward the relevant documentation to the head of the institution. Section 2. The procedure for applying the disciplinary sanctions referred to in Article 62, Section 2, is initiated by the head of the institution by notifying the interested party of the breaches with which they are accused and assigning them 10 days to present their justifications. Section 3. The head of the institution, having assessed the employee's justifications, if the case falls within this jurisdiction pursuant to the following, Section 8, proceeds where he finds the grounds for it to apply the sanction. Section 4. If the head of the institution deems that suspension or dismissal should be applied, he transmits the documents to the Disciplinary Commission of the Roman Curia, informing the interested party. Section 5. Such suspension, dismissal, and removal from office are communicated in writing to the interested party by the head of the institution pursuant to the, quote, regulations of the Disciplinary Commission of the Roman Curia, in quotes. Refusal to accept such communication is equivalent to receipt. Minutes of these actions, including the refusal to accept, must be kept. Section 6. The suspension and dismissal from office, referred to in Articles 64 and 65, are applied by the head of the institution in accordance with the decisions of the Disciplinary Commission of the Roman Curia and communicated to the Secretariat for the Economy. Section 7. The declaration of dismissal by right pursuant to Article 67 as well as to the precautionary suspension pursuant to the subsequent Articles 69 and 70, are applied by the head of the institution. Section 8. The oral and written warning and the pecuniary fine referred to in Article 63 may also be applied by the Secretary or the Undersecretary. Section 9. The provisions referred to in the previous paragraphs are transmitted to the Secretariat for the Economy. Chapter 6. Precautionary suspension, Article 69, Section 1. For any employee against whom criminal proceedings have been initiated in the Vatican City State or in another state, precautionary suspension may be ordered by the head of the institution. Section 2. The same measure may be adopted by the head of the institution for serious reasons against the employee even before the disciplinary proceedings against him have begun or been concluded. Section 3. An employee suspended from service as a precautionary measure receives full remuneration, excluding any compensation relating to attendance at work or the performance of specific duties. Section 4. The precautionary suspension order is revoked when the reasons that required it cease to exist. Article 70, Section 1. Any employee against whom restrictive measures of personal freedom have been ordered by the competent judicial authority of the Vatican City State or other states shall be immediately suspended from service by the head of the institution. Section 2. In the case referred to in Section 1, an employee placed under precautionary suspension will have their pay suspended and may be granted in agreement with the Secretariat for the Economy a maintenance allowance not exceeding half their salary in addition to any family allowance. Section 3. The provision referred to in Section 1 may be revoked by the authority that issued it due to ascertained facts and circumstances. Section 4. In the cases referred to in Section 1, when the proceedings conclude with a judgment or decision of acquittal by the competent judicial authority or the disciplinary commission, respectively, the suspension is revoked and the employee is entitled to the emoluments not received, minus the deduction of any maintenance already paid. Section 5. In any case, the head of the institution reserves the right to subject the employee to disciplinary proceedings in relation to what has emerged in the criminal proceedings. Title 11, Termination of Service, Article 71. Section 1. The heads of institutions and the secretaries or ecclesiastical equivalents, having reached the age of 75, must submit their resignations to the Roman Pontiff. Section 2. The heads of institutions, the secretaries, and the lay directors have reached the age of 70, cease from service according to the procedures established in the Ordo Servandus Proprio. Section 3. Ecclesiastical undersecretaries are members of institutes of consecrated life and societies of apostolic life, and those equivalent to them retire upon reaching the age of 72. However, cessation of service takes effect only from the date indicated in the provision adopted by the Secretary of State after consulting the head of the institution to which they belong. Section 4. Members of the various bodies of the Roman Curia cease to hold office upon reaching the age of 80th. Those who are members of said bodies by virtue of the office they hold cease to be members when they leave that office. Article 72. During the sede vacante, cessation of service is regulated by the Apostolic Constitution Universi Dominici Gregis. Article 73. Section 1. The retirement of staff is established by the regulations of the Vatican Pension Fund. Section 2. Termination of service, however, takes effect only from the moment it is communicated in writing in accordance with the following Article 74, Section 1. Article 74, Section 1. For 10th level officials, the termination measures referred to in the previous Article 73 are adopted by the Secretariat for the Economy after consulting the head of the institution. For the remaining personnel referred to in Article 3, the termination measures referred to in previous Article 73 are adopted by the head of the institution. Section 2. As a rule, by reason of their specific ecclesial status, secular clerics and members of institutes of consecrated life and societies of apostolic life dependent on the Holy See, after 5 years, possibly renewable, having served in the entities of the Holy See, return to the pastoral care of their diocese eparchy or the institutes of societies to which they belong, with the termination of their employment relationship with the Apostolic See. Section 3. By reason of their specific ecclesial status, secular clerics and members of institutes of consecrated life and societies of apostolic life dependent on the Holy See, even if hired prior to this regulation, may be assigned to other services in the diocese or in their institute or society with the termination of their service to the Apostolic See. This transfer, which does not imply any less favorable judgment towards the interested parties, occurs at the request of the respective ordinary or competent superior, accepted by the Holy See or by order of the Apostolic See after contacting the competent ordinary or superior. Before adopting such a measure, which will be binding, the interested party's opinion will be heard. Section 4. For termination of service, for disciplinary reasons, the provisions of Articles 65 to 68 apply. For termination of services due to resignation from office, the provisions of the following Articles 78 to 80 apply. Section 5. The provisions regarding pension and severance pay apply to employees who terminate their service. Article 75, Section 1. The provision of exemption from service due to illness is issued when the conditions set out in Article 58, Section 3 occur. Section 2. Except in the case referred to in Section 1, unsuitability due to illness, which may result in exemption from service, is certified through a joint medical examination by a commission composed of the Director of the Health and Hygiene Department of the Government of the Vatican City State and 2 physicians, one of whom may be chosen by the Director himself from outside the Vatican City State Medical Corps, in accordance with the regulations of the same department. The interested party may seek assistance from a trusted healthcare provider upon request and at his or her own expense. Section 3. In the event of exemption from service due to illness, the interested party is entitled to the pension and severance payments to which he is entitled. Section 4. Except for the cases referred to in Section 1, once the period of suspension of employment due to illness has ended, an employee who has been deemed fit for work must resume service within the deadline set by the Directorate of Health and Hygiene of the Government of the Vatican City State. In the event of failure to comply with this obligation, Article 80E below applies. Article 76, Section 1. In cases of injury or illness resulting from work-related events at the end of the period referred to in Article 7 of the current, quote, rules for the regulation of benefits due to personnel who have suffered physical or mental injury from an accident or contracted illness resulting from work-related events, in quotes, anyone who is not fit to resume their activity will be dismissed from service by order of the Secretariat for the Economy if it is not possible to assign them to other duties. Section 2. Unsuitability to return to service is determined by the medical board referred to in Article 5 of the rules cited in Section 1 in accordance to the procedures of the same article. Article 77, Section 1. Temporary employment may be arranged, subject to the approval of the Secretariat for the Economy, following the closure of the institution or the reduction of its staff, if in the latter case, the interested party cannot be assigned to other offices or other roles within the same institution. Section 2. During the period of availability, full remuneration is paid, excluding compensation relating to attendance at work. Time spent on availability is computed for purposes relating to seniority. Section 3. The placement of temporary leave of absence is communicated to the interested party in writing, indicating the reason and the effective date of the provision. Section 4. An employee placed on standby who, when recalled to service, does not rehire him within the time limit set is declared to have resigned pursuant to Article 80B. Section 5. The duration of the temporary placement cannot exceed 1 year, after which the employment relationship is terminated. In this case, the interested party is entitled to the pension and severance payments to which he or she is entitled. Title 12, Resignation from Office, Article 78, Section 1. An employee who tends to resign from office must make a written declaration giving at least 1 month's notice, unless otherwise agreed with the head of the institution. Section 2. Failure to comply with the deadline referred to in Section 1 will result in a withholding from the severance pay equal to the monthly salary or fraction of the missed notice period. Article 79. The resigning person is required to continue fulfilling his official duties until the due date. Article 80. Anyone who, without justified reason, is considered to have renounced and is declared as such automatically fails to resume service on the date set in the letter of appointment referred to in Articles 12, Section 2, and 16, Section 3. B. Fails to resume service within the time limit set after being recalled to service in accordance with Article 77, Section 4 of these regulations. C. Does not intend, if Italian, to benefit from the exemptions from personal service to the Italian state pursuant to Article 10 of the treaty between the Holy See and Italy and the Executive Protocol of September 6, 1932. D. Is arbitrarily absent from office for 5 consecutive days. E. Fails to resume service after the maximum period of leave provided for in Article 60, Section 8 and 61.3 has expired, if the suitability has been ascertained within the terms indicated in Article 74, Section 4 of these regulations. Title 13, Economic Treatment, Article 31, Section 1. Staff remuneration consists of the following elements: A. Basic salary. B. Special indexation supplement, ASI. C. Any other salary components such as biennial seniority increases or other forms of variable salary increases or similar provisions. D. Allowances pursuant to Article 87. Section 2. Remuneration is subject to Social Security, welfare, and severance pay deductions. Section 3. To determine the daily portion of the salary, the sum resulting from the base salary, accumulated biennial increments, special indexation addition, and any allowance referred to in Article 87 is divided by 25. To determine the hourly portion, it's divided by 150. If the weekly hours pursuant to the previous articles, 847, Section 1, are other than 36, the hourly position is determined by dividing the monthly salary by the result obtained by multiplying 1/6 of the weekly working hours by 25. Section 4. Compensation for holiday, night, and overtime work governed by specific specific legislation is paid using the wages for the month following the one to which they refer. It is not subject to the withholdings referred to in Section 2. Article 82, Section 1. In the second 10 days of December of each year, the 13th month salary is paid, consisting of the basic salary, accumulated seniority increments, a special indexation addition, and any allowances referred to in Article 87. Section 2. The 13th month's salary is paid in full for continuous service throughout the year. For periods of less than a year, it's due at the rate of 1/12 of each month of service performed. Fractions of months will be considered proportionally. Section 3. For periods spent in an employment position that involves the reduction, suspension, or deprivation of salary, the 13th month's salary is reduced in the same proportion. Article 83. The basic monthly salary is set at each functional level by specific provisions of the Secretariat for the Economy. Article 84. In order to guarantee the purchasing power of the salary, a special indexation supplement, ASI, is paid monthly, which is periodically updated according to the methods indicated by the relevant legislation. Article 85. The amount of seniority increases or other forms of variable salary increases or similar institutions and the payment methods are governed by specific regulations issued by the Secretariat for the Economy. Article 86. Employees sent on assignment outside their usual place of work for a period that includes at least one overnight stay, pursuant to Article 51, Section 4, are paid compensation according to the criteria established by the Secretariat for the Economy. Article 87. The Roman Pontiff issues specific regulations prepared by the Secretariat for the Economy after consulting the heads of the institutions which regulate the allowances provided for in this regulation. Article 88, Section 1. At the end of the service provided, the employee is entitled to severance pay in accordance with the procedures set out in the, quote, settlement rules, in quotes. Section 2. In the event of the worker's death, the severance pay is due to the heirs in accordance with current legislation. Section 3. Any advances on severance pay received over the years by ecclesiastics appointed as cardinals during their service must be returned or offset when the severance pay is paid. Section 4. The severance pay is received by ecclesiastics who, following the cessation of active service, have been appointed cardinals is to be considered correctly received and not subject to restitution. Title 14. Other provisions of an economic nature. Article 89. Staff can benefit from the following specific provisions regulated by specific rules. A. Family allowance. B. Family benefits. C. Mortgages and loans repayable through salary deductions. D. Severance pay advances. Title 15. Appeals. Article 90, Section 1. With the exception of matters falling within the jurisdiction of the Disciplinary Commission of the Roman Curia, disputes relating to administrative measures of the entities referred to in Article 1, whether individual, multiple, or collective, for violation of the specific regulations applicable to the employment relationship, will be resolved through recourse to the Labor Office of the Apostolic See in accordance with its statute. Section 2. The tacit rejection of the application by the institution is also considered an administrative measure if the institution fails to adopt any decision within 90 days of receiving the interested party's application. Section 3. Anyone who believes that one of his subjective rights in matters of employment has been infringed by an administrative provision, unless the provision itself emanates from the Roman Pontiff or has been specifically approved by him, may file an application in accordance with the preceding Section 1 within 30 days of notification or communication, or, in its absence, of actual knowledge of the provision or of the expiry of the term referred to in Section 2. Section 4. The interested party has the right to appeal in accordance with canon law against the disciplinary measures of suspension and dismissal referred to in Articles 64 and 65, and in the event of a lack of competence on the part of the bodies referred to in the previous Section 1. Title 16, Other Provisions, Article 91. The implementation methods referred to in the previous articles may be established by measures issued by the Secretary for the Economy after consulting the Secretary of State. Article 92. With the entry into force of this regulation, all provisions of the regulation referred to in the previous Article 1, Section 2, which are incompatible with provisions of the preceding articles, are repealed. The positions acquired by employees pursuant to the job descriptions of the respective bodies duly approved remain unchanged on a personal basis. This regulation, approved ad experimentum for a period of 5 years, is promulgated through publication in L'Osservatore Romano and comes into force on January 1st, 2026. After the aforementioned period, if no changes have occurred, it is to be considered definitively confirmed. Given in Rome at St. Peter's on November 23rd, 2025, the Solemnity of our Lord Jesus Christ, King of the Universe, the first of my Pontificate, Leo pp. 14. Then there's an Annex 1. It says Francis Apostolic Letter in the form of a motu proprio, containing provisions on transparency in the management of public finances, April 26, 2021. And it says Section 1. The individuals classified are to be classified in the functional levels C, C1, C2, and C3, including the cardinal heads of dicasteries or heads of entities, as well as those who have active jurisdictional administration functions or control and supervision functions referred to in Section 2, including the individuals referred to in Articles 10, 11, and 13, Section 1 of this regulation, and 20 of the regulation for the lay executive staff of the Holy See in the Vatican City State, must sign upon taking of office or assignment in every 2 years a declaration in which they attest a. Not to have received definitive convictions for international crimes in the Vatican City State or abroad, and not to have benefited in relation to the same from pardon, amnesty, clemency, or other similar provisions, or to have been acquitted from the same due to the statute of limitations. B. Not to be subject to pending criminal proceedings or, to the declarant's knowledge, to investigations for crimes of participation in a criminal organization, corruption, fraud, terrorism or related terrorist activities, money laundering, exploitation of minors, forms of human trafficking or exploitation, tax evasion or avoidance. C. Not to hold, even through a third party, cash or investments, including shareholdings or interests of any kind in companies and businesses in countries included in the list of jurisdictions at high risk of money laundering or terrorist financing as identified by a provision of the Financial Supervisory and Information Authority, unless the declarant or his blood relatives within the third degree are resided in said countries or have established their domicile there for proven family work or study reasons. D. That all assets, movable and immovable, owned or even just held by the declarant, or the compensation of any kind received by the declarant, to the extent known to the declarant, originate from lawful activities and do not constitute the product or profit of a crime. E. Not to hold, to the best of the declarant's knowledge, shares or interests of any kind in companies or businesses that operate with purposes and sectors contrary to the social doctrine of the Church. F. Not to hold, even through a third party, cash or investments, including shareholdings or interests of any kind in companies or in businesses in countries included in the list of non-cooperative jurisdictions for tax purposes identified by a provision of the Secretariat for the Economy, unless the declarant or his or her blood relatives within the third degree are resident in said countries or have established their domicile there for family, work, or study reasons, and such assets have been declared to the competent tax authorities. Section 2. Active administrative functions are those that involve participation in proceedings that result in the assumption of financial commitments of any kind by the institution. The jurisdictional functions referred to in paragraph 1 are only those of judicial nature. Paragraph 1 does not apply to support staff or control and supervisory bodies. The office of the Auditor General, acting as an anti-corruption authority, shall issue a provision identifying the offices and positions to which the reporting obligations pursuant to the paragraph apply. Section 3. The declaration referred to in paragraph 1 is kept by the Secretary for the Economy in the declarant's personal file. A copy thereof is sent, where applicable, to the Secretary of State. Section 4. Where there is reasonable cause, the Secretary for the Economy, making use of the structures designated for this purpose in the Holy See or in the Vatican City State, may carry out checks in the veracity of the declarations presented. Section 5. Without prejudice to the cases of criminal liability, failure to declare or a false or mendacious declaration constitutes a serious disciplinary offense pursuant to Article 76, Section 1, Number 2, and entities entitles the Holy See to claim any damages suffered.